Uh, Good evening, viewers. I feel great pleasure in welcoming all in this webinar. I'm also welcoming the SP sir, who is going to moderate the entire thing, oversee, and also I'm thankful especially to the speaker of the today's seminar, Sir Padamchand Kincha sir. I think, sir, the way you have agreed to give us time, the committee is thanked for your this participation in this today's webinar. Then I am also Srinivas sir. Always, whenever we have called him, he has given all. I think he's leaving all his personal work or official work for the shoot. We are thankful to you. And Gaurav Singhal Bhai, is also available every time. And my vice chairman, who's going to see, his in the deep night somewhere outside India, and still he's awake and attending this. And then CA Rishabh Agarwal, who's going to moderate this session. Friends, let me tell you now the webinars, because the pandemic has gone. This webinar, the shoot is not that encouraging for the CP hour. For learning, we are still open for all these webinars. So the question during the off hour, that why no CP hour? So the CP hour are there, but they are unstructured. So the topic which we have chosen, last week we have taken the amendment in the finance budget, and the act was discussed at great length, and it went up to 8:30 that webinar. Now the direct tax committee this year, as you all know, that it has been merged with the international tax, and there is only one direct tax, domestic and international, this year. So we have great duty to perform on both the side. I do not know what expectations will be able to come for the viewers and the users. Friends, we have taken today the recent development in international tax locally and globally. Locally and globally, the word we are using, we have chosen it, that what development in international tax is taking place in India and outside India. And as such, we'll be dealing today all our great speakers. I know they are rare commodities. They are not available otherwise. And the way they have given their time, that is remarkable. So the webinar will provide the opportunity to discuss and analyze the recent changes in the international tax and their implication for business. Especially our distinguished speakers will provide valuable insight and perspectives on various aspects of Pillar 2 developments. That is one they are going to handle. Then virtual digital assets, crypto, they are going to handle. The impact of MLI, they are going to handle. And they are going to analyze some of the UAE corporate tax. And rest depends upon the viewers, what they want. The recent development in the UAE, there are two courses which we have, certificate courses which we have recently concluded, one in Dubai and one in Abu Dhabi successfully, and we are going to hold the examination also. But the discussion which is taking place in UAE corporation, in this some of the area where we think that the member must encash the opportunities which are lying there, in MLI, equalization levy, complexities of the P issues, digital taxation, compliances in transfer pricing in respect of especially the UAE taxation. The recently I have attended one seminar or discussion of various accounting standard setters in New York, Norwalk, wherein beside the sustainability, the hot topic which has been discussed about the accounting standard regulators was the virtual digital assets. And I have explained them then what we are doing, how we are taxing, what are the difficulties, and what crypto is legal, illegal, everything. We try to explain them, and on the basis of that, they are going to provide the IFRS guidelines on how to present the cryptos, what are the disclosures which are required, and which are other things which are required, and taxation impact, what will happen around the globe. So all these things, they are in the discussion in the all over the world. But I know that in virtual digital assets, our battery bank here of the speaker, they are going to take a lot of issues. The participant is requested to post their queries, and the moderator will handle the queries to the extent whatever they can do it in this seminar. So once again, I'll just brief the session that the panel members today, we have Sir Padam Chand Kincha sir, then Srinivas sir, Gaurav Singhal SP sir will be overviewing the session. Rishabh Agarwal will moderate the session, and my vice chairman will though give a final concluding remarks, but still I would request him, if he want to give an opening remark, he is most welcome. With this, I hand over to first of all my vice chairman Piyush Chatterjee, and then to SP sir.
Thank you very much, Chairman sir. Thank you very much. I welcome all the panelists for the day, SP Singh sir, moderator, and the other panelists, Srinivasan sir, Gaurav, Padam Chandji, also the moderator, Rishabh Agarwal. It's a heartiest welcome to you. And the topic is so important today. The registration itself speaks about it. And I'm sure the next 2 hours will be very important. It would be very crucial. It is going to cover the international tax totally and the recent developments, which is very important. It is the new area of the practice. If the people are not doing into the practice and who all already involved into the practice would be aware of this topic. And especially when the speakers like Kicha sir, Singhal sir, Srivasan sir are there, who are the panelists stronger. I think so it would be a very insightful session. So I welcome all the participants and I request you all to be attentive to this. I'm sure you would be benefited by end of this. So I would, with this short words, thank you again, Chairman sir, for giving me this opportunity. I will again be there in the concluding remarks after we have heard all the panelists. I will there try to conclude that. And now I would request the moderator to take this session further. Thank you.
Thank you, sir. I'll request SP sir to begin with the technical session by setting the backdrop of today's panel discussion and what all we are going to cover, what will be our approach, and how we'll go ahead with it. SP sir, please.
Thank you. Thanks, Rishabh. In fact, it's my honor and pleasure to be part of this webcast organized by ICAI on a very important topic of the recent developments in international taxation locally and globally. I would like to thank ICAI and particularly CS Sanjay Agrawalji, Chairman, Direct Taxes Committee, for giving me the opportunity to be part of this webcast. It is an honor to be part of the panel consisting of stalwarts like CA Padamji, CA PV Srinivasanji, and CA Gaurav on this. Sorry, Gaurav, I'm not adding G to your name. Their vastness of knowledge and readiness in sharing their knowledge and experience is very, very commendable. As rightly said by Sanjay ji, all these three persons are always at the back of call by the ICI, and they are very happy to share their knowledge and experience. And it is also our good fortune that we have a very young, vibrant, and highly knowledgeable Rishabh as the moderator. I am also honored by the presence of CA Piyush Ji, Vice Chairman, Direct Taxes Committee. In fact, friends, the saying, I mean, that it is the change which is only constant holds more true in respect of international taxation than many areas with which I interact. We see changes in the way we conduct our business, the way we behave with one another. Digitalization and globalization have had a profound impact on economies and the lives of people. And the speed of the modernization or the changes have been accelerated in the 21st century. These changes have brought with them challenges to the rules for taxing international business income, which have prevailed for more than a century. And due to the mismatch and various factors, this has created base erosion and profit shifting, requiring bold moves by policymakers to restore confidence in the system and ensure that profits are taxed where economic activities are carried out and where value is created. All countries are worried about domestic tax base erosion and profit shifting. We know it more as BEPS, due to multinational enterprises exploiting gaps and mismatches, not within the country, but between the countries also. Unfortunately, developing countries, being highly dependent upon the corporate income tax, BEPS has bigger impact on their economy. Hence, tackling BEPS effectively is a global issue requiring coherent global approach. Appreciating the spread of BEPS and the debilitating effect of BEPS on the finances of many countries, particularly developing countries, as I mentioned, for the first time ever in the history of taxation matters, OECD and G20 countries have pooled their resources to develop BEPS packages to equip governments with instruments needed to tackle tax avoidance, tax evasion. The best part is that for developing countries, it is not only that they are only participating in the discussion, but their voices are equally heard as any other member of the group. The group is committed to implement the BEPS measure, to undertake peer review concerning the BEPS minimum standards, and to finalize the remaining standard setting works, in particular in relation to transfer pricing. In view of the importance of dealing with the tax leakages in digital economy, Action Plan 1 of BEPS is directed towards digital economy. They have come up with two-pillar solution with a detailed implementation plan, which have been endorsed by G20 members as well as the central bank governors. And it is likely that they are going to implement from either end of 23 or beginning 24. And just to give you a very brief about these two, Pillar 1 applies to the multinational enterprises with global turnover exceeding 20 billion euros and profitability above 10%, whereas Pillar 2, or which is known as the Global Anti-Base Erosion GLOBE rules, are designed to cover multinationals with much lower threshold. In fact, it's 750 million euro of turnover. So basically, you can appreciate that Pillar 2 will have the greater impact. Fortunately, between the two, the Pillar 2 is easier, and it appears that many countries across the globe are implementing Pillar 2. There are a lot of work still to be done in respect of Pillar 1, and it's likely that they will come into force in a foreseeable future. There is lack of clarity on the concept and the administrative aspects of these two pillar approaches. Let us see how it develops, and it will be very good to hear from the panelists how they look at, how they unclutter, how they make it the things much simpler for us to understand the action which are being taken, the impact on the economy, impact on the taxation issues. No, friends, in spite of these, there was a thought in the minds of all the stakeholders that if these are going to be implemented, they will need amendment to the existing DTAAs. And 3,000 DTAAs, if they are to be amended one after another, I don't know how many generations will take to undertake this. Fortunately, the good senses and bright ideas prevailed over the participants and the administrators, and they have come out with a very nice concept of the multilateral instrument. They may not be unique so far as international treaties are concerned, but in taxation, this is a unique concept. It enables modifications of scores of DTAAs in one go. So, friends, understanding MLI very fine. In their impact on the taxation system will be something which we will like to hear. If not now, maybe in. As has been rightly said by Sanjay ji, a lot is happening in our treaty partner countries or trade partner countries. UAE being the most important one, they have brought in the taxation laws affecting the international transaction as well as transfer pricing. And as he rightly said, all the stakeholders in the two countries are very keen to understand the finer points, and this panel may take up and try to simplify concepts. The other thing which is happening is that both within India and simultaneously, law is being changed to encourage international investment. And the two aspects which are very important is virtual digital assets law regarding the virtual digital assets. This may appear complex because there are many knots which are still to be opened up or to be clarified to all the stakeholders. And the other one is the law regarding the GIFT City, because India is interested in developing as a financial service provider. Last but not the least are the new the landmark decisions which have been pronounced by the Honorable Supreme Court and also by the special bench of ITAT. The former in respect of transfer pricing administration and the latter in respect of application of the tax rate under DTAA to dividend distribution tax. A lot is happening, friends, in the arena of international taxation. I am sure because of the time constraints, the panel will take up and Rishabh will ensure that the panel discusses the more important of those. I look forward to learn from the deliberations and the questions which you will be putting up to the panel. Over to you, Rishabh.
Thank you, sir. And thank you for...
Just a minute, Rishabh. Viewers, you must be seeing all of us in a normal dress, specifically on the request of the senior, that when we wear tie and coat, the discussion sometimes is not so open. So this is something unique we have done. That is why otherwise I will be challenged by my president in the official engagement. You are not there either in the Indian dress or in the suits. So this I want to mention. And let me just give the numbers of the viewers. We have around 1,800 in the international tax viewers. So we can see this, the panelists today are so important for us. And I think they will come to your expectation. With this background, I'm sorry that I have interfered in this giving this information, so that they should not misunderstood us that why they are not in suits. Thank you very much. Rishabh, over.
Thank you. And without further ado, I would thank SP sir for putting the backdrop so clearly and elaborating on what we will discuss. And I'll just give a quick introduction of all the panelists here. Why I said quick, because there is no one in the international tax fraternity or someone who wants to learn international tax who do not know our panelists or do not know about them. Even, small details everyone discusses about our panelists. So that is very eminent and prominent from the number of participants over here as well. So the first panelist is Padam Chand sir. So I think even he has lost count on how many lectures he has given, and I'm a fan of his writing. So I will just focus a little bit over there. He has more than 30 years of experience in this field, catering multinationals and Indian companies, also some HNIs. And he has authored various books. Again, lost count of papers he has authored in journals. And we took liberty that he was with us, so we could discuss a few things that he is taking up in his next paper. The next panelist with us is PV Srinivasan sir. Sir again has more than 33 years of experience, including experience in the industry. And we do not see a lot of people who come into consulting or academics per se after being in industry. So sir, this is like a guiding path for a lot of people who are in industry right now. He has argued various cases, not just in India, but abroad as well, and giving advisory on international tax to, again, multinationals and Indian companies on varied issues. And that you will be seeing it today with the breadth of the coverage that we are taking with this panel. The last speaker is Gaurav Singhal, sir. I look up to him always when I see someone who has made a made a name in this field, and purely on the basis of knowledge. Again, very experienced person with more than 2 decades of experience. He has founded various ventures. One of it is Saksham Ventures. I think it's a knowledge sharing venture, which I understand. And he's a regular faculty at ICI, different forums. And I think he has never shied away from showing up and taking up new challenges or new topics here. So this is a very short introduction of our panel, and I skipped on introducing SP sir earlier before his backdrop. So he is an ex-IRS, very learned person, and I am privileged to be in touch with him, have conversations with him informally, formally, and share screen with all of you. And SP sir is also the advisor for the Direct Tax Committee. Last year for the International Tax Committee, now which has been merged with the Direct Tax Committee this year. So it is all his guidance about the topics, about the panel, and the flow and everything is under his guidance. And sir, I would request you to jump in wherever you feel necessary. And I'll also request the other panelists to jump in wherever you feel necessary to give comments and make this discussion very comprehensive. And for the participants, please shower in questions. When there are about 1,800 participants here, I expect a lot of questions to come in. We'll try to cater everything, but not promise to cater everything, just giving a very consultant level answer. So requesting permission from the panelists to begin with the first question, sir.
Yes, sir.
Right. So when we were discussing about this topic to take, and when we have used this word recent developments, so we meant it very literally recent, because we are covering things as recent as last week. This is the dynamic power of our panel. So opening the question to the complete panel is, as SP sir rightly pointed out, about a special bench decision of Mumbai ITAT in the case of Total Oils Limited, which is in regards of the DDT that was abolished in 2020, and the beneficial rate, or let's say the rates for the dividend withholding tax rates for the dividends in the relevant double tax agreements. Sir, I'm opening this question to the complete panel about your comments. Do you agree with the judgment made or the arguments taken, or what is your view on this?
I'll begin. Nobody else is commenting. And before I begin taking up this question, sincere thanks to the Institute for giving us this opportunity to come on a very important topic and share the platform with a lot of dignitaries here. The questions, I know that Rishabh has many to ask. And the time may not be necessarily sufficient to discuss all these questions, sincere. But the question, in my opinion, the objective should be to discuss a matter thoroughly, than completing the number of questions that Rishabh possibly has in his repertoire. And the better way would be to understand a topic from an intensity point of view than just touching the fringes of the topics concerned. And as Rishabh rightly mentioned, this is a very important decision about when a dividend is paid to a non-resident shareholder, you are liable to pay dividend distribution tax under 115(o). There's a specific rate provided for under the statute. The question is, and the question before the special bench was, would that rate as prescribed under 115(o) get impacted and therefore get reduced by the rate of tax on dividend as prescribed under the treaty? So if 115(o) has 15% tax, a treaty, for example, may have 10% tax or say even 5% tax in some cases concerned. Can you impose this treaty rate of tax onto the 115(o) regime and then say the maximum amount of tax you can deduct under 115(o) or pay 115(o) shall be limited to that as prescribed under the treaty? And as Rishabh rightly mentioned, that this is something that is relevant up to March 20, because thereafter we'll come back to the classical system of taxation. And somebody then therefore asks the question, hey, why is this topic relevant today? Because you're coming back to a classical system. In my opinion, this topic is relevant from a conceptual analysis, and that becomes very important, critical, because if you look across and scan through the Income Tax Act, we possibly have concepts similar to or akin to this dividend distribution tax being discharged by the company. For example, today we have the buyback tax also, where on a buyback of a security concern, the shareholder makes a gain, but the company discharges the tax. Therefore, what we discussed today will be relevant for buyback tax. There are similar concepts otherwise also under the Income Tax Act. For example, we have a new section 45 subsection 4 introduced into the statute. The gains made by a partner are taxable in the hands of the partnership firm on retirement or on dissolution. So somebody else is paying tax on a gain made by another person concerned. We have a common concept of a clubbing of income under section 64. Somebody else's income is clubbed in my hand, therefore I'm required to discharge tax liability. So the concepts of this dividend distribution tax could be relevant there. We have also a question of a tax-free perquisite being given by an employer to an employee. The tax has to be borne by the employer concerned. It is exempt in the hands of the employee. Therefore, this becomes relevant in terms of akin concepts, not necessarily identical concepts, but concepts akin to the tax liability of one person being discharged by another person. And therefore, in that context, the discussion of the special bench decision in Total Loyal's case becomes very relevant. What are the points that the special bench said that 115(o) rate will prevail over the rate as prescribed under the treaty concern? We will look at those reasons and then come back to some counters to those reasons. Possibly the tribunal has failed to appreciate or has overlooked in the course of its decision concern. The first reason, I'll be very brief on this. The first reason the tribunal said in the special bench was that this is a case where 115(o) has a non-obstante clause. It overrides everything else. Therefore, it overrides section 4 of the Income Tax Act also, which talks about income of a recipient concern. And to that extent, therefore, when it overrides the Income Tax Act provisions, it will stand on its own by itself. And therefore, what is given in section 115(o) shall ultimately have to be given effect to, regardless of whose income it is and what section 4 provides. And if section 4 cannot be applied, obviously section 90 should not be applicable. Therefore, they said that we all appreciate that there is an economic substance of transaction, that it is dividend. But then that economic substance of a transaction should yield to the legal framework that has now been created under the statute, that will be a tax on the dividends payable by a company concerned. And therefore, the statutory scheme should prevail over the economic incidence itself. And the special bench very interestingly said, look at the terminology of 115(o). It's a taxation on distributed profits and not on distributed income. It's a profit of the company concerned, and therefore it's a profit of the company that's being distributed. It's not a profit of the shareholder, it's an income of the shareholder. But the law talks about profits being taxed, and those are profits of the company itself, and therefore, liable to pay tax at the stage of the company itself. It can't be therefore regarded as a tax on behalf of a shareholder concerned. After that, they say that we have to be a case where, if you look into the declaration of dividend by virtue of Section 8, there will be a declaration of dividend by virtue of which there will be a case where that becomes the debt due from the company to the shareholder. But on that day, that's not the record date, you will not be able to identify a shareholder. And when shareholder becomes difficult to be identified and you're levying a tax, it obviously means it shall be a tax on the company, not on the shareholder concerned. They also went on to say that, look into 1150, 1B was introduced there. A grossing up concept was introduced under the statute concern, which indicated that, therefore, you will have to pay so much of tax such that after the amount of 115 is removed, it will tally with the amount of dividend received by the shareholder concerned. This grossing up is a very, very clear indicator that it's a tax payable by the company concerned. And they went on to the provisions of 115 note to say that you're not entitled to any deduction whatsoever. Section 57 is not retracted. You will not be able to claim any tax credit on this matter. And therefore, because of this provision of 115.0, they made a statement that this will be a tax on the company, not on the shareholder concerned. And they said, this is a case where this is a dividend is not the dividend distribution tax is not equivalent to a TDS, not equivalent to a tax payable on behalf of a shareholder concerned. As a result of it, therefore, we stay put with the proposition that it will be a case of a tax payable by the company. And they went into the treaty also, and they said, look at the treaty concern. When is the treaty applicable? The treaty is applicable if you are a resident of the other country. Whom are we examining? We are examining the company which is a resident of India. Is it a resident of any other country? The answer is no. When that company which is paying the dividend, which is liable to pay tax, is not a resident of any other country, how can he invoke any treaty? Because the basic test of treaty being applicable is not being satisfied in that case. They also went on to make a statement that levy of tax is a sovereign power of government concerned. If the sovereign power of the state concerned, they can make a statement that this tax will be discharged by the company and not necessarily by the shareholder concerned. As a result of all of these propositions concerned, they came to a conclusion that this is a levy on the company and not on the shareholder, and therefore, once it is not a tax on the shareholder, it cannot be a case of the dividends rate as prescribed under the treaty being superimposed into 115 law. These are the points in favor. Now look at what kind of points against, and that can be a real point of debate itself. Now, first question is, we entered into a treaty, and we therefore made a promise to the other government concerned, dividends from this country shall be taxed at this particular rate only. Are we, by a unilateral amendment to the domestic law, reneging on our treaty obligations concerned? Because under the Constitution, we are supposed to honor and comply with the treaty obligations concerned. By making a unilateral amendment to a domestic statute, can you renege on your treaty obligations concerned? 1. 2. Look at what the law tells us. Look at what ICDS tells us. It says the substance of the transaction shall prevail over the form of the transaction. The substance of the transaction, economic substance, is that it is a tax and therefore the income of the shareholder concerned, and it is that tax on the shareholder which is being shifted to the company. The rate may be uniform, may not be going to the slab rate of the shareholder concerned, but necessarily it's a tax on the shareholder because it's a tax on dividends. That dividend can be an income only of the shareholder. It cannot be an income of the company. As a result of which, therefore, it will be a case where the economic substance of the transaction by virtue of ICDS 1 should prevail over the form of the transaction concerned. There is a protocol applied in the judgment itself. The protocol between India and Hungary was applied to say that, look at the India and Hungary protocol. They made a statement that under the protocol, there is a specific mandate and a reference that the tax leviable on the company under 115.0 shall get modified by the tax as applicable under the treaty. Now, the treaty wordings across the countries are largely the same. If India's understanding vis-a-vis Hungary is this, that it shall be available, that the treaty rate shall superimpose itself on the 150 rate, and the language of the other treaties being the same, why can't that ratio be extended to all other treaties concerned? We have a very classic case of Raymond's Limited, where the India-US protocol on make available was extended to India-UK treaty for the reason that the terminology under the treaties were absolutely identical. What does the treaty language tell us? It tells us that it is a tax on dividends. It doesn't say whose tax of a shareholder, tax of a company. It doesn't say anything at all. It says tax on dividends shall not exceed 5% or 10%, regardless of whose is being taxed in the hands of, being the tax in the hands of a shareholder or in the hands of a company. The treaty does not specify whatsoever. It shall be a tax on dividends. If 150 no tax is therefore a tax on dividend, which it is so, it should be a case where therefore the law of the treaty should prevail over the rate as applied under 115 itself. If there is any ambiguity in this type of regard, it has to be therefore also resolved in favor of the taxpayer concerned. And there are a number of reasons also additionally to talk about a case where there may not be so much of clarity under the law. There may therefore be a case where there is an ambiguity available under the statute, as a result of which, if there is a doubt, that should be resolved in favor of the taxpayer concerned. Why is it I'm saying that it is a tax on dividends? Look at exemptions given. For some time, they said you have an SEZ person who will be exempt from DDT. You may have some concessional rates of tax available. As a result of which, therefore, when you build in an exemption from the applicability of 115, though, you're looking at the character of the person who's receiving the dividends. The character of the person, therefore, indicates that 115 should not be applicable. And as a result of that characterization, it's possible to make a statement that it is definitely a case of a tax on the shareholder concern only. Look at a classic case of 115R that is there in the statute today. There is a mutual fund that distributes dividends concern. A mutual fund's income is exempt under 1023D. Now, when you talk about a mutual fund distributing dividends, it's also liable to pay dividend distribution tax. Now, if you were to call it as a dividend distribution tax on the income of the mutual fund, then 1023D should have given an exemption to the mutual fund itself. As a result of it, therefore, to say that you are still liable to pay tax indicates very clearly it's not a tax on the dividends of the, it's not a tax on the income of the mutual fund, but it is a tax of the shareholder concern. If you have to make a statement that this is a tax on the income of the company, then you have to necessarily bring in the proposition that if a company has agricultural operation, like a tea operation or coffee operation, only some percentage of the income will be liable to be taxed in the hands of the company. And when you make a statement that this is the income of the company itself on which liable to pay tax, it means that you necessarily have to bring in the concept of agricultural income and have a truncated form of income on which there could be a dividend distribution tax, which actually is not happening in this case concerned. As a result of which, therefore, it's a case where you are able to lead a lot of arguments concerned that it is a case where it's the income of the shareholder, it's the income falling under the definition, it's the income falling under section 4, falling within the definition of tax as defined in 2 subsection 43, which definition of tax should necessarily yield to the rate of tax as prescribed under the treaty concern. And what's happening is the board itself has clarified in the memorandum explaining the provisions of the finance bill, as also in circular number 763, that we are bringing about this change as a result of administrative convenience. Not anything else, but administrative convenience. It's becoming difficult to find out and levy tax or collect tax from the hands of the shareholder concerned. It's an administrative mechanism, not a conceptual difference to say it's a shifting of the tax from the shareholder to the company concerned. And therefore, that administrative convenience indicates that it still remains the tax on the shareholder. If it remains the tax on the shareholder, the treaty rate should be applicable, and accordingly, 1150 should be modified to that extent. So the question, therefore, is the case of a tax on a classical model or trying to oversimplify matters to say that it will be a tax on the company 150. No, that oversimplification, in my opinion, may not necessarily be correct. These are certain preliminary observations there, and that are over to the panel members for the contribution.
Gaurav sir, I heard you had some pretty interesting views on this. This was the reason we decided to take this up. Please.
Rishabh, thanks. And it is an honor to be in such an august gathering. Thank you to the ICI, everybody, for this. Rishabh, I personally feel that we have had some kind of a disloyal relationship with the concept of taxation of dividends, right? We have kept on changing our stand all the time. And yet, somehow, it appears we are expected to behave like, what was the name of that girlfriend of Superman, Louis Lane, right? She's so naive that she doesn't understand that whenever there is an emergency, Clark Kent vanishes and Superman emerges. So probably the two are the same people. Similarly, in this case also, what we see every time is that the moment dividend distribution tax is introduced, taxation of dividend in the hands of shareholder goes out, and vice versa, right? That happens every single time, like clock. Therefore, is such a huge correlation not very clearly indicated that essentially, in substance, the idea of dividend distribution tax is to tax the income being dividend and not really the distributable profits of the company. That's my first preliminary view. This decision significantly hinges upon this conclusion, which the ITAT has arrived upon, which the Honorable Special Bench has arrived upon, that it's not a tax on the income. Instead, it's a tax on the distributable profit of the company, which is strange because, in a sense of speaking, if you look at the content of 115.0, it starts with referring to income by way of dividend, right? Secondly, is it actually only a matter of administrative convenience that the dividend taxation has been shifted to the hands of the company? Because if that's the case, and therefore if we are not collecting shareholders tax from the company, then that should mean that if the company fails to deposit the dividend distribution tax, the shareholder should not be asked to pay that tax, right? I repeat, if the company does not deposit the dividend distribution tax, the shareholder should continue to enjoy their exemption. Yeah. But is that really the case? If we look at section 10, subsection 34, second provision, it clearly says that the entire, let me actually look at it, provided further that nothing contained in this clause means the clause which talks about exemption of dividends, the ones which have been subjected to DDT, nothing contained in this clause shall apply to any income by way of dividend received on which tax under section 150.0 has been paid. So has been paid. The most important point that I want to highlight is when the dividend distribution tax has been paid, then and then alone this exemption will apply. If the dividend distribution tax has not been paid, then will the exemption under section 10 subsection 34 be enjoyed by the shareholders? No. And if that's the case, are we not clearly saying that, come on, it is a shareholders tax which has been collected from the company, but if the company doesn't deposit that tax, in that case, the shareholders have to cover. I also think that this is a case of a treaty override. But having said so, I would also point out that this is not such a straightforward fact or such a straightforward issue. Because if one were to hold that the dividend distribution tax is effectively a tax on behalf of the shareholders, it would also have some very interesting fallouts. For example, in that case, all the shareholders, Indian shareholders, Indian resident shareholders included, they might argue that now that it is clear that the dividend distribution tax is effectively a tax on us, the shareholders, that means that the dividend income is no more exempt and was never exempt, which means all this while, all the expenses that were being disallowed under section 14A, because everybody felt that the dividend is an exempt income, all of those expenses will no more be subjected to 14A and therefore should be allowed as a deductible item in the hands of the shareholders. So therefore, it's a nuanced issue. At a high level, I would say that prima facie, I feel that there are more areas to look into in this decision, and the controversy is not dead yet. It will live on. That's my take.
Thank you, Gaurav sir, for bringing out the legislature framework behind this judgment. And Padam sir has squarely summarized all the arguments taken in favor and against, along with his comments on the judgment. Srinivasan sir, I request your comments of what are your views on the judgment and how it is going, and what will be the future course of litigation, if any.
I may just point out one more section. There is the fringe benefit tax, which almost had a parallel language. We call it pari materia, as in 115.0. It was in one of the questions, which was the FAQs, the answer given is that FBT is a surrogate tax. If it is a surrogate tax, itself means it's a tax which the company bears on behalf of the employees in the case of FBT. If the material is the same, the language used in the sections are more or less identical. Should not dividend also be interpreted as a surrogate tax? And if the principle of surrogate is introduced, obviously it's a tax which is borne on behalf of the shareholders by the company. And if that were to be so, then many of the construct of the Honorable Tribunal decision will possibly require some amendment. So I would think the only point I would like to add to what others have said is that please look at the FAQs under the FBT. One of the questions would say it's a surrogate tax. And if that can be used in an interpretation, say in higher forums of litigation, possibly that will also add to the weight that the government always thought of these taxes as surrogate one.
Right, sir. Thank you for bringing out a different perspective or aspect. I mean, I don't think I would have connected it to that point over here. And I mean, I got the suggestion that we should take the questions only at the end so that a good discussion should go ahead, because the questions which are coming in are from varied topics, probably connected and unconnected to what we are discussing right over here. So I would like to push on the next question to the panel, and that would be for Padam, sir. So we have seen the recent judgment of SAP Labs India by the Honorable Supreme Court in a transfer pricing matter, wherein the Honorable Supreme Court has discussed about the powers of the High Court to tell that the ITAT is not the final authority for the fixing of the comparables. So I have a very intriguing question here. That is the selection of comparables an issue over here, or conducting a comprehensive FAR analysis the bigger issue?
Before we go into the Supreme Court decision, it becomes important for us, therefore, to get into the High Court decision on soft brands. To me, the problem is not of the soft brands decision per se, but the manner of applicability of soft brand decisions later on. So we had a soft brand decision where two questions were the substantial questions of law before the High Court of Karnataka. Question number one was on particular companies, whether they are good comparables as compared to the tested party or the taxpayer in that instant case. And second case was on the aspect of the related party transaction filter of 15%, whether it is appropriate or not. These were the two questions raised before the High Court of Karnataka. Rightly or wrongly, the High Court has focused only on the first question. In the entirety of the discussion, it has therefore expounded the law only in relation to the aspect whether particular companies mentioned there specifically the substantial question of law, do they constitute good comparables? And it is in that context certain observations are made by the High Court. Therefore, it becomes important that when we look into the transfer pricing aspect, as is also the case in any other matter of law, we may be examining particular facets of the case concern. The question, therefore, would be asked at each type of examination, whether the matter under examination leads to an inference of fact, and therefore it is a question of fact, or it is a mixed question of fact and law, or it is a pure substantial question of law. So only in the third case where there is a substantial question of law that you have the doors open to the High Court. Therefore, we have to understand as to the transfer pricing law, what can constitute a question of fact, what can constitute a question of law, and then get into the job of finding out whether that question of law tantamounts to a substantial question of law. When we talk about the aspect of comparables, what are we doing? We are doing the job of comparing, matching, and finding out whether in the light of the functions performed by the taxpayer concerned, somebody else who is called upon to be a comparable, does it satisfy the test of comparability? And therefore, you apply various filters as given under the statute. So the question is, what filters do you apply to come to the comparables? Therefore, before you come to the comparables, we apply a number of filters concerned. Those filters could be the related party transaction filter, the turnover test filter, the working capital adjustment. They could be functions, assets, and risk. So we apply the filters. And then after applying the filters, you come to a set of comparables. Which comparables, then on the basis of the FAR analysis, you're going to come to a conclusion whether that company is a suitable comparable or not. So in the exercise of the final comparability, we're only pairing and matching. And in that context, therefore, if there is a reasonable examination by the tribunal concerned to say that we have seen the functions of the taxpayer, we have also understood the functions performed by the comparable companies, and on an analysis of these two, on a comparison of these two, we come to a conclusion that company A is good comparable, company B, C, D are not good comparables. Now, that conclusion on comparability, is it a question of fact or a question of law? Or is it a mixed question of fact and law? To the extent of your pairing and matching to say whether it's a good comparable, that should necessarily be a question of fact only, not a question of law. But before you come to the comparability, you apply a number of filters concerned. Related party filter, the turnover filter, economic adjustment filter, capacity utilization filter, different year filter. So the application of filters can give rise to a question of law because you're applying the law, you're applying Rule 10C, you're applying 92C to a question of fact to come to a legal conclusion. The question, therefore, is about the applicability of filters can give rise to a question of law. There could be various other issues in terms of the provisions itself, of the whole chapter 10 itself, whether this is a deemed international transaction, whether you will have a cost contribution agreement in place itself, whether it gives rise to a corresponding adjustment. Is there a case where you have some sort of a related party transaction? So many issues can come about. So not all questions can be said inevitably to be questions of fact only. They have to be, in many occasions, a question of law. But therefore, going back to the Karnataka High Court decision and its observation, and it made a detailed analysis of what the tribunal did in relation to those companies concerned, he went to an analysis and said, yeah, on the basis of these findings of the particular companies concerned, we confirm the finding of the tribunal for the reason that we do not find a substantial question of law to the extent of these companies, whether they can be regarded as good comparables. I don't think, therefore, there was any flaw in the Karnataka High Court decision in Soft Brands case. But what happened, therefore, was this decision was being applied indiscriminately to all transfer pricing matters. Whatever be the question, be a question of fact, be a question of law, it began, the soft brand was being applied in a manner to get rid of the problem itself. Transfer pricing possibly was found to be a difficult subject, and therefore they said, hey, this is a question of fact, no such a question of law, apply soft brand case and dismiss the case. That indiscriminate application of the soft brand case, in my opinion, was the problem, went to the Supreme Court. Both the department as well as the SSC both went to say that they have applied soft brand cases wrongly because they've not got into, there's no examination by the High Court to say that whether the tribunal has been perverse in its finding, whether the tribunal, when it gave analysis of comparables also, could have possibly used irrelevant material, could have ignored relevant material, could have ignored certain propositions of law, could have ignored certain binding precedents. That could have therefore caused injustice to the participants, to the parties concerned. So therefore, there was some flaw basically in the analysis and the conclusion of the tribunal. Possibly you could have made a statement that there is a perversity involved in the final of the findings of the tribunal, and a question of fact can be open to be addressed by the High Court if that question of fact is accompanied by an allegation of perversity, which the High Court finds is a valid complaint made, with a valid argument made, and therefore we can say even a question of law, a question of fact can be upturned by the High Court concerned. Save to that extent, therefore, it's important for us to be very mindful of the fact that what can tantamount to questions of fact, what can really be questions of law, that will have no standardized answer for this. And therefore, to that extent, I thought the Supreme Court was correct in making a statement that all these matters had to go back because there was an indiscriminate application of the soft brands case. In that context, they made certain observations as to what shall be a substantial question of law. And there are certain interesting observations that to look at. They said it's a substantial question of law, and they compared the language of Section 109 of this Civil Procedure Code to say what is 260A talking about is a substantial question of law and not a substantial question of law of general importance. No, need not necessarily be a question of general importance. It has to be a substantial question of law as far as that case is concerned. It may incidentally involve some people large at the society at large. It may therefore involve the public at large. Therefore, it may tantamount to, because of the applications on the entire public at large, can become a substantial question of law. But if it is substantial to resolve the list between the parties concerned, unless you come to that conclusion, you will not be able to resolve the list between the parties concerned. If therefore that material, it is considerable, it is of very great importance to the discussion before the High Court concerned, it shall therefore tantamount to a substantial question of law, therefore inviting the doors of the High Court being opened for a purpose of resolving that dispute concern. So to that extent, the Supreme Court decision in soft brand case has nothing much to do except reiterate the general principles of what can be a substantial question of law. And on the facts of the case, they sent back the matter to the High Court because they found that there is a indiscriminate application of the High Court decision, which they found was wrong. And in my opinion, obviously and rightly so, because you couldn't have said every other conclusion of the tribunal is a question of fact, and therefore I don't have to entertain that decision. That attempt by the High Court's concerned to brush aside their application of mine to transfer pricing case has been rightly set aside by the Supreme Court to say that go back, examine whether the tribunal has applied its mind, whether the comparables are correct. To the extent of the choice of filters, find out if there's a question of law. But it's only a matter of comparables concerned. Have the tribunal applied valid principles? Have they not ignored precedent law? And then come to a conclusion that on an examination, we find that the comparability is an exercise of fact. Therefore, we don't or we decline to interfere. Beyond that, it is required to. It now, therefore, the bounden duty by the Supreme Court directive for the High Court to examine whether the tribunal did its job correctly or not. And to that extent, therefore, I don't think I could find any fault in the ultimate conclusion of the Supreme Court in this.
Processes where the taxpayer and the tax department come to a solution which is accepted by both and is beneficial to both. That's the win-win situation. So here what's happening is that, a decision needs to be taken as early as possible, because that is how, business environment will improve. So I feel that the burden, instead of, in fact, in rejoicing on the decision, I would feel that there is an increased burden on the tax department to come out with a solution to reduce the number of litigation and to give proper direction to the transfer pricing officers to come to a conclusion which will have greater acceptability than simply going through the process of tribunal, High Court and Supreme Court. Because many a time the tax department goes to High Court and Supreme Court depending upon the quantum of litigation. And that's my worry. That's the only thing which I would like to add to this.
Thank you, sir, for bringing in this perspective also from the tax authorities' side and the mindset. And I think we have discussed this about all the arguments and the questions taken up in the judgment. And it would be time to move on to the recent amendments made in the Finance Act 2023 in the international tax space. Srinivasan sir, would like you to elaborate and what were the major changes brought in and how it actually impacts us or the businesses.
For the session, I will possibly capture only one which is absolutely major, and it impacts almost every international transaction. Number one is the rate change with regarding to royalty and FTS. And this got introduced almost at the fag end when the finance bill got introduced in the parliament and got passed. So nobody even had a clue that these rates are getting amended. That's fine. That's the process of lawmaking. We'll leave it at it. The impact is that the earlier rate of 10% now becomes 20% under the domestic law. If we look at it, possibly 20% will be one of the highest rates in most of the treaties. And treaties will provide for lower rate, possibly in some cases 10, some cases 15, and so on and so forth. So obviously, for a lower tax, every payment will be subject to seeking a treaty relief, that the payer will have to apply the treaty relief and grant the treaty relief based on the entitlement of the recipient. If this were to be done, obviously the treaty provisions will have to be studied a little deeper. So domestic law is no more the ground on which you will be able to deduct tax at source. The application of treaty will have to come in necessarily. And therefore, the understanding of the treaty will be a compulsory requirement for most taxpayer, most CAs as they issue the certificates under the law. The next point which we have to look at is, if 20% is the tax under the domestic law, obviously there's a mandate for filing a return under Section 139(1). This mandate of filing a return under 139(1) was removed on the basis that if you are paying tax under 115A at the rates prescribed in 115A, then you don't have to file a return. Now, if the rates are now 20%, and unless you are willing to suffer economic loss in terms of taxes in India by applying the domestic law, possibly most companies which are seeking a treaty relief, they will all have to file a return in India. So that virtually enhances the amount of the volume of returns which will be filed consequent to this, even though all the taxes would have been discharged. But the fact that there's a mandate to file a return, and obviously that will be subject to assessment wherever required, that becomes the next highest, what's called, one may call it an administrative risk. Many MNCs will see it as a tax risk itself, number two. The third one is, of course, there's a tussle on Form 10F, and there's a extension on manual filing without obtaining a PAN. When somebody is not required to obtain a PAN, then he need not actually file electronic 10F. He can file a manual 10F. The dates have been extended up to September under notification. But with this amendment, assuming that manual is no more allowed, that means every MNC will, in any case, they have to seek a PAN. Now they will be compelled to take a PAN for that reason too. So you'll find that PAN is one more method of administering the foreign companies will come. I would think it is a measure which earlier the domestic law was more favorable. The government has thought that let us make the domestic law less favorable and let the treaty relief be qualified on its own terms. That must be the thinking on which it's done. But a huge administrative work will come, not only for the payers, but even for the recipients of those streams of income. It will be quite a struggle. So I would say that it has changed the entire dynamics of cross-border payments. What is royalty? What is fees for technical services? Earlier, we didn't have to struggle to interpret because except we'll say it is not royalty or it's not FTS. That was the only struggle, not on the rate at least. Now we have to struggle on the rate also.
Right, sir. You rightly pointed out that how big an administrative trouble it would be. But I would say it also open up opportunities for Indian chartered accountants who are into advising for the withholding tax rates or who are into compliances for return filing and making these administrative tasks, not just for the Indian companies, now for the MNCs, for foreign companies as well. So it's like can be seen as an opportunity also.
It's an opportunity for all of us as practicing chartered accountants. I will not dismiss it. Except that we have to build up skills now. Yes. Earlier, it was easy to apply a 10% rate and issue a certificate. Now we have to build up our skills to interpret what is royalty, both under the domestic law as well as under the treaty, and see whether it will go out of the ambit of royalty itself, and so on and so forth. So the interpretation skills. Earlier, 10% was possibly an affordable tax. 20% may not be an affordable tax. I'll say practicality comes up to some stage, not beyond.
Right, sir. And mostly the transactions that were happening in this space were like the cost was borne by the Indian counterpart and not by the foreign counterpart. So definitely now for the practicing chartered accountants, I would request, sir, you also please give this as a warning that please do not sign Form 15 CBs blindly now. Because
a lot of scrutiny is going on Form 15 CB and CA also, which are the parts which are being filled, which are the parts wrongly filled. I think the government is looking into Form CA and CB very intensively. So nobody should take it is actually an attestation work, and that attestation work should not be lightly taken at all, because the consequences is that you are allowing tax of a non-resident to be taxed or not to be taxed. Yeah, that is a very huge responsibility on all of us. I can only take in the context that there are enough books available on royalties and FTS. Certainly, most recent books also can be studied. And constantly we have to update on the decisions twist from time to time.
Right. Thank you so much. And this was, I think, one of the most important amendments that was brought in this space, and you have squarely covered it. I mean, the day it was released, I don't think I slept for 2 nights reading this, that, oh, what will happen now? What are the implications? And rightly pointed out, especially for the electronic filing of 10F, because the wordings that not having PAN or not required to obtain PAN were not so clear. But I was trying to make a flow chart that what would be the decision-making process when even for us, when we have to advise it to clients. So by this, I would say that we have explored the locally part of our webinar when we say the developments in international tax locally and globally. So let's fly out to UAE now and try and explore the global aspect and what has been happening in UAE since, let's say, last year, April, since the public consultation document was released and the law was released in December. And till now, wherein every day there are certain decisions, notifications coming up, which are bringing more clarity to UAE law. So Gaurav sir is with us, and I would like him to expound on certain provisions, important provisions. And before we see how they are different or similar, but we'd like to see on how do they impact Indian businesses, because we are seeing like a very big outmove for expansions in UAE. I mean, I am clueless that till yesterday, let's say, there was no tax, but still a lot of people were not thinking on expanding in UAE. But now that the tax has been introduced at a very nominal rate, which you will be taking up, but people are still moving there. So please try and touch upon that and certain important provisions and overview of UAE corporate tax for our viewers, sir.
Thanks, Rishabh. Thank you. I think the way I would start is let's understand what's UAE all about, right? It has the size which is roughly equal to West Bengal, right? I googled that up, by the way. It has, geographically speaking, it is divided into, well, 7, or politically speaking, it is divided into 7 emirates. But actually, business-wise, commercially, anybody who's doing business in UAE, he looks at UAE into 2 parts, right? The first part is what is called the mainland, but the more important part, really, from a business perspective, is what we call the free zones, right? Now, what are free zones? Free zones, there are about some 40 to 50 free zones in the UAE. And these are the places which are geographically earmarked areas. Some of them are for specific kinds of businesses, some of them like multi-commodity centers. You can do any business you like there. But the idea is they have a commitment from the respective emirates that they will not be taxed. And they will not be taxed for 10 years, 15 years, well, 50 years, right? That's how the commitments run. It's not that the mainland had any taxes either, right? The free zone part, they have this commitment, but even for the mainland, practically no taxes. There were some old Emirati decrees, but they taxed only some very specific kinds of businesses, oil extraction and so on and so forth, but otherwise, no taxes. Now, what changed? OECD BEPS project, the global minimum tax proposal, and as a subset thereof, the subject to tax rule is what we see right now being implemented. A 9% rate is what UAE proposes to implement in the respect of businesses and corporates which are doing activities out there, and this will get implemented with effect from those financial years which begin on or after 1st of June 2023. The reason why it states so is that, unlike, for instance, the Indian tax laws, the businesses out there, they have a freedom to choose any financial year that they want. We see businesses which mostly follow calendar year. Some of them have a June beginning year. Schools follow, for instance, or April or August or September beginning year. Some of the clients have an incorporation date following year. We have some clients which have a 52-week year. But the bottom line is, for instance, if you follow calendar year, then from 1st of January 2024, a 9% tax will start applying to you. And by you, I mean a business or a corporate which is active in the UAE. So far, there is no QDMTT, qualified domestic minimum tax, top-up tax of BEPS of 15%. That's something which the FTA is still looking at. The individuals will not be taxed in respect of their salary income, personal incomes. But again, if the individuals are doing business, they too will be taxed. There are concepts such as exemption limit of 375,000 dirham. There is a small business relief. But the bottom line remains, now UAE will no more remain a tax-free jurisdiction, right? Are we saying that even the free zones will start getting taxed? The reason why I'm focusing so much on free zone is, if you look at it statistically speaking too, more than 30% of the total national income of UAE actually comes from the free zones, right? So the answer to the question of whether the free zones will now be taxed or not, like most of the questions in life and a lot of questions in taxes, it's like yes and no, there are conditions. So if the free zones satisfy some of the conditions, then some of their income, which is called the qualifying free zone income, will continue to enjoy a 0% corporate tax rate. And those qualifications, those conditions, it appears based upon the public consultation documents, are in a sense of speaking something like the IFSCs out here in India. I'm not saying they're only limited to the financial services sector, but for instance, an IFSC either deals with the non-resident or with other IFSC units in the GIFT City. Right now, we have only GIFT City IFSC. So it's like that even in the context of free zones. How would they be taxed? Well, the starting point will be IFRS financial statements. And just like we see in India, there will be some adjustments, some items of expenses which will probably be disallowed, and we can talk about that, in a few minutes from now. But bottom line is the accounting profits will be the starting point, and from there we will arrive upon the taxable income, and it's that taxable income which will be subjected to tax at the rate of 9%. But not all incomes are necessarily taxable. Dividend, for instance, is not taxable. And there is no dividend distribution tax either. So it's not taxable in the hands of the shareholder. It's not taxable in the hands of the company, so long as it's being declared by a resident entity to a resident shareholder. Even if a UAE-based entity is earning dividends from non-residents, there is a concept which is that of participation exemption, and that's where we see actually that the UAE corporate tax law is a kind of an amalgam of several kinds of tax laws. I see a significant, sort of touch of UK tax laws, participation exemption. It's there in UK laws, Dutch laws for that matter, right? So I see a significant influence of other kinds of tax laws too. Rishabh, you asked that how would it affect? You touched upon this thing, that how would it affect the Indian businesses, right?
Yes.
I think the first thing I would say is that it would significantly affect Indian professionals. When you go there, you realize that practically the entire finance industry, the large part of finance industry, profession included, right, is actually being run by us Desis, right? So this is a huge opportunity for Indian professionals who are active in the field of international taxation, just that we don't have to make the mistake of assuming that the tax laws in UAE are going to work in a similar fashion to that of India. I won't think that's the case. And also, it's a very interesting observation you made, Rishabh, that a lot of businesses are flocking to UAE in spite of the fact that it is now introducing a 9% corporate tax rate. And in fact, there was an Economist article exactly on this thing, right? That a lot of businesses are actually moving to UAE, which actually proves a point in a sense of speaking. It's not that the businesses mind paying taxes, really, Rishabh. It's what they want is a simplified, approach towards taxation, and that's what you see in a significant sense of speaking. I'm not saying that I'm doing comparisons here, but still, what you see is a very, very simplified tax law for the time being. It's less than 100 pages, and I mean, even if I add up all the cabinet resolutions which have been released after the release of the real corporate tax law, which we call the Federal Decree 47 of 2022, even after that, there have been several cabinet resolutions which have been released. I don't think any of the cabinet resolution has crossed 4 pages. So even if you add all of these up, it's not 100 pages total, right? If you add up the procedure law, okay, even the procedure law is still less than 100 pages. I think an important area where Indian businesses should be aware about is now the UAE corporate tax law will start taxing permanent establishment. And what we see when we are working upon advising our clients in the UAE is that a lot of Indian businesses actually are carrying out a good number of trading activities. In fact, general trading is one of the most common kind of licenses in the UAE. And therefore, one should be aware of the risk of creating, for instance, an agency PE in the UAE. The UAE corporate tax law also has a concept of state-sourced income. Also, the whole issue around not ordinarily resident definition change for what we call the stateless Indian citizens. Now that is probably going to be relooked at now that some of the Indian citizens who are carrying on businesses or profession, because profession is also included in the definition of business in the UAE, now that they will be taxed, how will the Indian Income Tax Act apply to them in the context of whether they will now be deemed as Indian tax residents or not? Because now they will be subjected to some kind of tax in the UAE. Rishabh, do you want me to talk about, you mentioned, do you want me to talk about the similarities and dissimilarities?
I would like that you expand a little bit on the dissimilarities, because similarities, the way Indian tax professionals are very creative, we'll relate it once we read. And as you correctly mentioned that the law is not even 100 pages, but a commendable job by the UAE government that they've tried to put all the international best practices that concise manner and very clear terms. There always will be a scope of ambiguity, because I told you we are very creative people. We'll find things to create issues and then solve and charge for the solution. That's how we function. But I would really like you to point on the dissimilarities between the Indian law and the UAE tax law, or maybe certain features which we really do not see in the Indian tax law.
That's really smart way of thinking about it. I'll follow your instruction. Firstly, the big dissimilarity is that there are not so many adjustments which are to be made when computing the taxable income, right? It's a comparatively easier process. There are some items of expenses which are not allowable, which are dissimilar, for instance, to the Indian tax process. Some time back, we had this, even in India, we had this obsession about what to do with entertainment expenditure and a degree of suspicion around entertainment expenditure, right? We see that very clearly in a black and white form in the UAE corporate tax law, in the sense half of the entertainment expenditure flat out is disallowed. But I think the big dissimilarities, if I have to look at it, is first of all, let me put it this way. Rather than the provisions, first of all, we have to understand that at a cultural aspect, there's a huge dissimilarity. And that's something that you'll not find it written anywhere. But when I'm saying the cultural aspect, I'm talking about the tax culture around it, right? For instance, in India, we see multiple level of appeals. We find that the appeals are pursued in a very specific fashion. We get a lot of hearings, stuff like that. That's really not the concept that we see. That's not the culture that we see in UAE. And while corporate tax is a recent introduction, UAE has had VAT for a few years now, and the economic substance regulations which were introduced in 2019, what we see is that if one receives a negative outcome in an economic substance regulations proceeding, then you file an appeal, yes, or a reconsideration application, yes. But can you file a long, lengthy submission, legal submission running into pages? No. Can you go and appear before any authorities? No. Can you demand a right to being heard? For the timing, you upload a submission and you pray to the Lord Almighty with all your might, right? So that's one fundamental, as I mentioned, that's a cultural difference. If I look at the law, there are some very interesting concepts. For instance, there's a concept of group level consolidation in tax laws. And it's there in several other laws. If we see We find this in US naturally. We find this in UK naturally. So there are a lot of laws in which there already exists the concept of consolidation, tax consolidation at a group level. We find that concept in the UAE corporate tax law as well. We also find that even if a corporate tax group cannot be formed, still there are certain benefits which can be availed by groups without forming a corporate tax group. So the idea of corporate tax group is if there are suppose 5 companies, 1 holding company, 4 subsidiary companies, all of them operating in the UAE, then they can opt that instead of being treated as 4 different or 5 different taxpayers, we will be treated as one single taxpayer. We'll file one single tax return. All intergroup transactions will get cancelled out. We won't have to worry about transfer pricing in respect of these transactions. So it's therefore simplistic. The general culture about preparing consolidated financials is very, very popular out here in the UAE as against preparing standalone financial statements for every single entity in the group. So therefore, they can continue to do that as well. They can offset the losses of one of the entity against others. These are all the benefits of the corporate tax group. Some of these benefits can be availed even without forming the corporate tax group, which is also another interesting distinguishing feature, which means if there is one company which has a common 75% shareholding with another company, both of them are in the UAE, then one company which has incurred a loss, what it can do, it can transfer its loss to the other company without even forming a corporate tax group. It's like lending your loss to the other entity, and not even lending, just give it away, right? You lose your loss, the other entity can utilize that loss in this very year. Frankly, we see this concept in Germany. I think in Germany it's called Organschaft. That's a concept. In UK tax law also there is a provision which allows a transfer of loss. The other big difference, as I mentioned already, is participation exemption, which means a UAE resident, if he is earning any dividend, or for that matter, even capital gain, from a foreign investment, suppose this is a UAE entity, and it's a mainland entity, it is earning any dividends from an entity outside, an investee outside of the UAE, could be an Indian entity, then that dividend will not be taxed in the UAE subject to certain conditions. Predominantly, the most important conditions are that this UAE entity should hold at least 5% or more of the ownership of the foreign entity which is declaring the dividend, and that foreign entity should be subject to tax at a rate more than 9%. So this is the concept of participation exemption. What else? Procedurally, there is no withholding tax at all. There are provisions which indicate that there will ultimately be some kind of a withholding tax, but at least for the time being, there are no withholding taxes at all effectively. There is no need to deposit even an advance tax. You deposit all the tax in one single go at the end of the year, and that's pretty much it. Yeah. Yes, I'll take a breath here. Rishabh, anything else that you want me to add here?
I think we have taken a good tour for UAE. Just one geographical or a general knowledge pointer that UAE is the country, Dubai is just one of the Emirates. Because whenever we talk simplistically, कि business कहाँ कर रहा है, दुबई में कर रहे हैं. But when you the companies operate in Sharjah or Ras Al Khaimah or Abu Dhabi, and fun fact that even Dubai is not the capital, Abu Dhabi is the capital, being the richest of all the Emirates. So that's just from on the lighter note and non-technical stuff. You've taken good care of the technical stuff. One thing that you really made it clear that why businesses are going to UAE because of the tax regime as of now, and also because I would say because of the infrastructure. And when I say about infrastructure, I've seen free zones coming up, like one of it called Digital Oasis, which is specifically for virtual digital assets or cryptos or NFTs, mining of such assets or mining or for the exchanges. Reason being, UAE has one of the maximum use cases across the globe for cryptocurrencies or crypto tokens. And we have seen how Indian virtual digital asset regulations are. So I would like Padam sir now to elaborate a little bit on how the tax regulations of Indian VDA are vis-a-vis to the other countries. And I know that they're not in UAE, but yes, how are they, and what do you think that whether these tax regulations that we have are encouraging the businesses to set up here, to bring this technology back home, or to use this technology in different other use cases, or they are a little discouraging in those terms?
If you talk about this crypto asset, that is one segment of the complications introduced by the evolution in technology, particularly the distributed ledger system and the cryptography. We therefore have crypto asset that could take the shape of a cryptocurrency, could be taking the shape of a NFT, could be taking the shape of so many other things. We're calling them in terms of tokens, utility tokens, security tokens, and whatnot. These are all manifestations of the multiple uses that technology is enabling business to drive. If you look at it historically, it is the compulsions of the market and the needs of the market drive value to a particular mechanism of transaction. Not necessarily, therefore, that you should be transacting only in currency. The public can, therefore, devise their own means of what, in their perception, is constituting value. For example, in the local trade, we had this initially certain IOUs issued by a particular person because he was valuable, because he was known, because he was trustworthy. The market accepted that, and the value created untradeable. It may not necessarily have been the legal currency of that particular jurisdiction, but because of the person issuing it, there was value involved. Today, we are having a manifestation of the very same concept, except that we are having this at a very larger scale. And actually, there is an article written by the moderator himself, on Rishabh Agarwal, on a couple of aspects on the aspect of crypto, and some statistics is given there are very interesting. And this is carrying forward from what statistics have been given on crypto from the OECD commentary, where they said it is about $300 billion in September 2020. But now, the latest article by Rishabh says that the total transactions in cryptocurrency has passed $3 trillion. He's making a mention that there are approximately 16,000 individual cryptocurrencies available in the market. The daily transaction is going to about $275 billion. There are 400 platforms of cryptocurrency. And therefore, you can look at the race that is happening to develop an economy that encourages crypto, because they're finding it's a very good cause of economic development. They would like to be, therefore, leads. And there is, therefore, a race across where he's talking about a UAE giving up a full city itself, a free trade zone only for VDI assets. Singapore is trying to do that. US is trying to do that. Therefore, there's a competition today that they would like to be a hub of crypto activities concerned. But the question is that, is it that easy? The answer possibly is no, because of the fact that technology is evolving. We are not able to understand the pace at which technology is evolving, and therefore, the characterization that technology is able to impart to a crypto is not, therefore, enabling a capturing of tax principles that could be applied to a crypto. When you talk about what you mean by the characterization being difficult, question going to be asked is crypto a currency? Is crypto a financial instrument? If it's a financial instrument, is it a currency? Is it a currency? Yes. If it's a currency, what type of currency? Is it a fiat currency or a real currency? That's what is a legal tender of a particular country. Is there a legal tender? Possibly no. Except for El Salvador, they will not be calling this as a legal tender. But then, is it currency? Is it therefore a financial instrument? Is it an investment? Is it a commodity? Is it an asset? Is it an IP? These are all difficult issues in terms of categorizing this crypto into one particular box to say this classification shall be uniformly applicable to crypto. So the classification difficulty because of technology and because of varied uses of this crypto is causing some difficulty in terms of understanding how to apply the existing principles of law to the income that is derived from a crypto concern. We're also having an issue where, by fundamental character itself, this crypto decentralized concept. central regulatory authority, like a bank, for example, should be a centralized authority which is monitoring, supervising, controlling all transactions in financial currency. We don't have a single authority which can be, therefore, the authority to whom we are going to report about the developments in crypto. This is a decentralized mechanism. The decentralization concept is therefore also giving rise to its own difficulties concern. If you have a decentralized concept, who do you think is the person to whom you're going to report? Difficult. Therefore, does it give rise to difficulties of identification of the person concerned? Does it give rise to anonymity? Are you going to therefore be able to hide your identity when you're dealing with crypto? If that is there, are you going to therefore avoid income tax? Are you going to therefore be a person who's involved in terrorist financing, narcotic financing? So many issues are coming about in terms of the decentralized concept. But from a tax angle, critical question that arises is, if this is a decentralized concept, where is the income, source of income? I understand that the persons who are earning the income could be miners, could be platforms, could be investors, could be traders. They are going to be residents of one particular country. So the taxation in the country of residence may not provide any difficulty, provided there's adequate reporting mechanism, because I made a statement about anonymity, about my possibility of concealing this. One could therefore find a lot of changes happening to reporting requirements as to have you had transactions in crypto, are you therefore holding cryptos concerned. So there will be possible a lot of disclosure requirements. The individual in his income tax return, as also by the exchanges concerned when they're dealing with this, possibly increased disclosure requirements will be the order of the day, by which the government should be able to say, we are going to anonymity and find out and track the persons, whether they are the persons who are actually involved in transactions of crypto. But more importantly, because of the decentralization, we have the difficulty of identifying the source. As it is, the action plan 1, we spoke about digital commerce under the BEPS action plan, spoke about it's very difficult to understand where the actual income is in a digital commerce concern, because there are elements they're not able to identify. Therefore, they're bringing about new parameters of identification source concern. So user is a source, transaction is a source, value is a source, value creation is a source. These are going to be difficult concepts, which therefore there is a juggle that is happening across the world to find out how they're going to evolve principles, how they're going to frame tax policy decisions as far as crypto is concerned, and how do we therefore classify the income that is being generated from this crypto concern. We also have the issues of valuation. Cryptos are going up, going down. So how do you therefore have a valuation for various purposes under the statute concern? There are therefore conceptual difficulties, but the excitement in the market is there. When the excitement is there, people are going to, anyway, rightly or wrongly, go into and latch on and transact in it. And they will therefore say, let the law evolve by itself. And this is a very critical area, in my opinion, that the government cannot say, I'll devise the policies myself. They will necessarily have to take into account the industry experts, the technology experts, and the academia evolving policies concerned. And work is happening across the world to understand how to capture this, the tax implications of this crypto concern. India has had its own ways of dealing with these things. It has a case where they've introduced a definition, a very comprehensive definition of VDA under 2 subsection 47. It has introduced section 115 BBH for taxing of cryptos. It has introduced 194S to say what shall be the TDS mechanism when transacting in crypto. It also amended section 56.2.10 to say that when you're going to give the crypto to a person who is not a relative concern, the person who receives the crypto with a virtual digital asset will be liable to pay gift tax. And interestingly, this amendment has happened under 56.2.10. Although for all of the type of assets, the word property is defined, and you borrow the definition from 56.2.7a. But 56.2.10 has been amended to say that crypto shall, the virtual digital asset, shall also be an asset, the gifting of which can give rise to tax implication. And we have had 2 circulars issued, circular number 13 and circular number 14 of 2022, dealing with certain aspects of the transactions in crypto and what shall be the tax implications. There is a lot of excitement in read the sections concerned. There's a lot of excitement. The crypto, the virtual digital asset is an information, a token, a number, an NFT. It may be something that is a store of value. Actually, there is a statement called as economics. Money is a matter of functions for a medium, a measure, a value, a store. So crypto fulfills all this. It has four functions: a medium of exchange, a measure. How do you know? Therefore, have a case of exchanging a particular items to each other. A value also is there. A store also is there. There's a store of value. It is only falling short of being regarded as a technical legal tender. Therefore, officially, government is not blessing it. Government is saying, "I'll come out with my own central digital currency, which will possibly be getting the status of a legal tender." But till then, you may have transactions of VDS. If there may be value in the perception of the public concern, we are yet to call it as legal tender. And therefore, there will be a case where the incomes from this transaction on transfer shall be taxable under 115 BBH at 30%. Now, 115 BBH does not draw a discrimination whether you're holding this VDA as either a stock in trade or as a capital asset. You will be liable to pay tax at 30% on either of them. And interestingly, they say you're liable to pay tax on transfer. So 115 BBH is only dealing with income from cryptos on transfer thereof. What happens to a person who is a minor who doesn't transfer, who earns crypto? How will it tax him? What will be the valuation mechanism? It will be possibly be ordinary income because he's earning it from some services being rendered. He'll be taxable as ordinary income as a professional or as an income earner. But 115 BBH says that all incomes, whether they're held as a stock in trade or as a capital asset, the income from transfer of VDA shall be taxable under 115 BBH. And interestingly, it says the word transfer for the purpose of 115 BBH shall be the same as is available to the transfer of a capital asset under 2 subsection 47. That definition will be applicable. Therefore, you can't have the common definition of transfer. It says whether held as a capital asset or otherwise, the definition of 2 subsection 47 shall be applicable for understanding when the transfer has happened, and 115 BPH will come into picture. And interesting regulations are there to say that you will not be able to get any deduction whatsoever except the cost of acquisition. No deduction whatsoever shall be available. Loss also shall be allowed to you as a deduction. Now, this could be a loss from a transfer of another VDA asset. Technically, the board clarifies so that shall not be available. Now, this gives rise to an interesting proposition, and therefore, I'm just giving a sample of a discussion. We'll have many more such discussions coming about because of the interplay of the definition and the charging sections concerned. I am holding 2 assets, both are crypto assets. I am transferring one at a gain, I am transferring the other for a loss. The simple rule would be by 115 BBH, I will not be able to set off my loss. I'll be therefore liable to pay tax on the profit made on the sale of crypto. That loss goes, I can't even carry it forward, and therefore it goes to waste. Now, when I pay tax, therefore, I'll be able to claim only the cost of acquisition as a deduction. I'll not be able to claim anything else at all. Now, this happens as far as a investor is concerned. What about a person who's carrying on a business, who therefore is in the business of buying and selling crypto? Now, is he paying tax on each transaction, or is he paying tax on the agglomeration of all transactions concerned? Because 224 would say it's the profits and gains that you're liable to pay tax on. It's not a tax on transactions by transaction. We don't therefore have transaction by transaction taxability. We don't have transaction by transaction computation. If I'm a trader in textile, I've sold something at a profit, something at a loss. They converge into my profits and gains at the end of the year. Therefore, that profits and gains is regarded as a single source of income as far as the SSC is concerned. If you were to apply that logic to say that profits and gains are the measure of taxing business income, and that's the source by itself, then when you're dealing with a person who's a trader in crypto, you'd possibly be able to lead an argument that in the course of arriving at the profits and gains, it will be an overall factor. It will therefore be a case where I'll be able to set off my VDA losses against VDA gains. And I'll then come to the aspect of profits and gains. And possibly, therefore, one could lay down an argument that in the case of a trader in crypto concern, it will be a case where the net amount is going to be taxed. And naturally, this process will be able to claim the loss from one VDA sale against the profit on another VDA sale if both of them are held by a person as a stock in trade. Therefore, this is going to be very interesting development that are going to happen in relation to the taxation of crypto. And there is a world over a good amount of energy being devoted, both by the governments and by the bodies concerned to understand. As mentioned earlier, El Salvador is a country that has regarded this crypto as a valid legal tender. There are certain countries that have banned. Venezuela and Bolivia had banned crypto. China is imposing a lot of restrictions. Some are encouraging. Singapore is encouraging. Japan is encouraging. US is encouraging. UAE is encouraging. India is taking a cautious stand to say that by its attitude, by inserting a very comprehensive definition and levying a tax of 30% on 115 BPH, now trying to give an indication that till the time we come out with a proper regulation, be sure you don't indulge in cryptos. If you're trying to, be sure you pay tax. And only then that will be a measure of discouraging, because we don't know ourselves what will be the tax situation evolving as far as this is concerned. As long as we get maximum amount of tax on these gains made, we will not be therefore concerned with the actual ramifications at the minor level or a minute level of the individual transactions and the tax policy decision. So to that extent, therefore, there is a very interesting situation awaiting us, as is happening in the questions of artificial intelligence tax implications, in metaverse tax implications, gaming tax implications. Crypto also, with its various forms, is going to give rise to very interesting tax implications. And therefore, for the tax professionals as a whole, there are very exciting times about how to unravel the new technology and also understand the tax implications attaching these technological developments.
Thank you, sir. I mean, you simplified it for us, and covered it very comprehensively. I just have a very funny yet intriguing question when we talked about gifting or transfer. So, sir, I have an anonymous wallet in one of my phones wherein I have kept certain crypto tokens. What if I fly out to Bangalore and give that phone to you and you own that wallet because it's anonymous? So whether will it be covered under either transfer or gift, because we are not relatives? So, it was just a very funny situation in my head, and I thought I should bring it out because a lot of things are happening of that sort, which probably, irrespective of such comprehensive regulations that we have made, as I earlier mentioned, we are very creative. We will think out of ways to escape or go around and about the law.
Obviously, because these are going to be a very interesting time for us. And therefore, there was worry, as it is, to say that are my mileage points liable to, are my accumulated point liable to. Therefore, government had to come out with clarification to say that in the following issues or in the following transaction, these shall not be regarded as VDS itself. And as you rightly said, therefore, if you were to come to Bangalore and take me to a hotel and I eat there and you pay it from your pocket cushion, is it going to be a gift to me, or is it going to be they're going to be very interesting situations concerned. Therefore, I made a statement that the anonymity is the issue today that's causing difficulty. And possibly, therefore, there'll be very close requirements of disclosure. Have you had transactions for your own ways? Have you transacted for somebody else's benefit? These are therefore going to be good disclosure requirements that are going to be built into the system of filing your tax returns itself, by which the government will be able to draw certain conclusions concerned to say that, yes, have you had a transaction which is coming under 56.210? Till the time the disclosure requirements are not adequate enough, possibly taxpayers will be able to take shelter of that non-comprehensive disclosure requirements and then say, I'm not going to get caught, and therefore what I do with my VDA is not going to be a case where government is going to come forward automatically with trouble on me unless they investigate my affairs very deeply and come to a conclusion that there is a transfer of VDA leading to a gift of 56.210.
SP sir, would you like to put a tax authority perspective, whether government is actually pursuing it, or give us something from your informal channels if we can?
I don't know what government is doing, but I have a couple of remarks to make here, because a transaction which is preceding, the business. This is a scientific, or you can say a bunch of people. In software.
SP sir, voice is not there.
No, sorry, you are completely audible to me.
Hello.
You are audible, sir.
Am I audible to you? Sure. So, in case of crypto, what we are observing that the technology is moving ahead of even the business leave aside the tax people. So the recourse which is open to the policy makers are twofold. One is that come out with some very simplified position and wait for the business to emerge and then come out with the regulation. Because you do not know the tax authorities or the tax policy makers, they are not fully aware of what are the types of transactions which are taking place and how the governments in other countries are trying to tackle that. So far as transfer pricing is concerned, the great advantage the authorities had while framing the transfer pricing regulation was that there were some actions by various countries, and the OECD came out with guidelines which form the basis for the development of tax law. So until and unless some international organization like OECD, UN, come out with a guideline to deal with cryptocurrencies, the different countries, as Padan ji has pointed out, are taking totally different approach. And the more varied approach will be in respect of taxation. So far as the approach of the government is concerned, Rishabh, they are, keeping a watch over how it is moving, and then they have put up a basic framework come to be known to them only when the transactions grow in India, and they come to know about the ways by which those are being used to move the profits from India. So those are the points at which there will be more direct legislation. Yeah, Rishabh.
Thank you, sir, for your comments. With this, I think we should move on to the next topic, which we wanted to discuss, and it's the elephant in the room, the very self-explanatory term of pillar. And this is a topic wherein once even the thought of it, we start pulling our hair that what has happened and why are we reading this. So I would request Srinivasan sir to elaborate on some countries have recently introduced the Pillar 2 rules, though with a deferred implementation. So how does this unbalanced implementation of a unified solution would impact countries which are not implementing Pillar 2 rules or are just waiting or looking forward to what other countries are doing? And with a little bit of introduction of Pillar 2 for us.
Yeah, let us first take the second part. You did use a good, some kind of a example that hair is being pulled, and it's quite apparent when you see me that hair is actually being pulled out, so we can say. So I would say that Pillar 2, broadly, it may not be very possible to go too much into detail, considering that we have some time left for the conference. It is a global minimum tax model rules. It has been prescribed by OECD, and G20 countries are there. There are more than 140 what is called inclusive framework members, if members to be in short. India is also one of the members, and all these members have agreed to levy a global minimum tax at the rate of 15%. How is that 15% calculated? It is calculated jurisdiction-wise. So you have to go into each of the countries or taxing jurisdictions and find out what will be the tax for all the entities within the jurisdiction. So if you have a subsidiary, you must take the subsidiary. If you got a PE, you must take the PE. The subsidiary need not originate from the ultimate parent. It can be a subsidiary of the PE. Also need not be a PE of the ultimate parent. It can be a PE of a subsidiary. So all these entities, be a subsidiary, be a PE, all of them are aggregated. The income of them, there's a globe rules which have to be applied. How the income is getting calculated? The agreed basis is that use the consolidated financial statements which are prepared at the ultimate holding company level. The consolidated financial statements are prepared by using accounting standards which are mandatory in those jurisdictions. So India possibly will apply Ind AS. There are many countries which will apply IFRS. So if there's an Indian ultimate holding company, then all the subsidiaries and PEs across the globe will apply the Ind AS standards to find out the local jurisdictional income. So ETR, while there's a little complexity to compute, essentially it's a book ETR. Go by the book standards. What is the book tax with some eliminations for deferred taxes and all. And you find what is the tax, which is the income which is computed under the consolidated funds for those jurisdictions. So if you are, for example, got a US subsidiary, USP, you will apply the consolidated financial statements rules and extract those related income and the taxes for those entities. Find out for ETR for each jurisdiction. If the ETR is less than 15%, then the jurisdiction itself can levy additional tax subject to meeting certain conditions and make it 15. For example, if the ETR for US, I'm just taking US as an illustration, US will certainly not be 15, less than 15. But assuming that US, the levy comes to 10% and the global minimum tax is 15%, US may want to tax the balance 5% also under the domestic law, so it can provide for catching up with that balance 5%. Assuming that US doesn't want to do that catch up and it leaves that 5% on the table, then it's called the top-up tax. The top-up tax will now be captured by the Indian ultimate parent in India. That means India will pick up the extra 5% and levy it as part of the Indian tax collection. So what would have been a tax payable in the US? Because US has not levied the tax, because it's below the global minimum tax norm, that a top-up tax will be picked up by India. Assuming that India also doesn't want to levy, it is not from the globe rules, or it is not even prepared to levy that extra. Even if it has got the globe rules in place, it doesn't want to levy this tax at all, then it will go down to the subsidiaries which will flow through before the US entity is there. So you have to go the top-down, what's called a waterfall kind of a mechanism. You start with the Indian parent, then go to the next level parent and find out the division as to how the US entity has got invested into. And that is how it will be caught up between the entities in between the ultimate parent and the US subsidiary. This is a mechanism which ensures that at somehow or other, 15% tax is paid across the jurisdiction. No jurisdiction can levy a tax which is less than 15%. If you were to levy, then it's not that the tax is saved there, it will be picked up by some other jurisdiction as a compensating levy. The issues, if I have to lay it now, this is called the income inclusion rule. This is the primary rule. It goes all the way to the parent. Then you will have, there are other kind of subordinate rules which will essentially say that you must take it to the next level if the parent company is not willing to do. Then subject to tax rules are also there, which essentially means that the source country can levy a tax based on the minimum standard, which is prescribed between 7.5 to 9%. And if it is levied only a withholding tax of, say, 5%, then it can catch up with another 2.5% to make it 7.5%. If it's 9, it can catch up to another 4%. So if the withholding tax on an income is only 5% on a source which is derived from a country, then it has an option to levy another differential tax of 2.5%. If it is 7.5 is the norm, 9% is 9%, 4% if it is the 9% is the norm. So this is the mechanics on which it broadly works. There are countries which have already adopted the globe rules. It is called globe rules in short. It is the anti-base erosion rules. And for convenience, it's called globe rules. South Korea, Japan have all implemented the laws already with a deferred date of implementation. The laws are all formulated on the basis of the model rules prescribed by OECD. So one may not find it too deviant from the model rules. The European Union has given a direction to give on the basis of the model rules, and that directive is already in place. There are 7 or 8 other countries which have got the draft rules in place. UK is there, Mauritius is there, Liechtenstein is there. So you find many countries which otherwise were possibly in the tax haven kind of understanding earlier, they've all also implemented these rules. So India has not done so much. In the sense, we do not know the budget of finance bill as well as the budget did not have any mention of globe rules. So there's no change in the Income Tax Act. But I may guess for 2 or 3 reasons why India may be deliberating as to what should be done. One, these are all my own interpretations, not that I've heard it from anybody. One is that what is the nature of this additional tax? Assuming that India has to levy this additional tax, what is the nature of this additional tax? Will it be like an equalization levy, which is not levied under the Income Tax Act, but nevertheless it's a tax? If it were to be an income tax, how it will be correlated to Section 4 with Section 9 of the Income Tax Act? Section 4 is the charging section. Charging section will relate to the income. Here, the top-up tax is actually not correlated to the income, but nevertheless, India has the right to capture the top-up tax. So whether the 4 and Section 9 will be really correlated. So if that were to be so, what will be the nature of the tax? Or it will be a tax in the nature of 115O, which we started at the beginning of this section, that put one more Section 115 and say there's an additional tax which will be captured by India for a failure of another low tax jurisdiction which has not levied the tax. These are the things which are possibly there. My comfort so far is that India has not introduced any levy on an ad hoc basis. Possibly the constitutional mechanism also will have to be looked at. If India, the constitution says that all taxes shall be based under subject to law, and under the schedules, if it is a tax on income, then the income also should be correlatable to the top-up tax. If it is not correlatable, whether it will be a tax on income will be the fundamental aspect which I will look forward to when the law is formulated. If it is not a tax on income, then it should be like equalization levy, another levy which is formed. Assuming that, let us take Cayman Islands as an example. If Cayman Islands were not to levy a tax, which is global minimum tax, 15% is not there, it doesn't levy any tax, then the additional top-up tax will be levied by India as the parent company for a moment. Then this 15% tax is levied as equalization levy for a moment. Tomorrow, Cayman Islands were to declare a dividend and the dividend comes back to India. Will there be one more tax on the dividend? Or there won't be a tax on the dividend? Will the dividend be kept out of the Indian tax regime? What will be the mechanism to address those kind of double taxation issues if I have to raise? One can say that India had already taxed the differential tax because the income did not suffer a 15% tax in Cayman Islands. That is why you have taxed it at 15%. Assuming there's a dividend which is remitted by Cayman Islands without a withholding tax for a moment, what will happen? Will the additional tax be allowed as a credit now? Or it will not be, or it's a tax on another stream of income, which is independent of what has been levied as additional tax. These are the areas which are slightly, or India, will it say that certain incomes, such as dividend, royalties, fee income, and even CFC income for a moment, if India were to have a CFC income, they will all be left to the source state. India will not tax them at all. That is what the globe rules envisage at that point in time. Will the domestic law replicate such a mechanism that will keep it away from the source itself so that India will not tax it at all at that point in time? So this is the question which I don't have an answer. I don't think many countries have answered it also. One thing we must remember that India has not administered taxes based on a consolidated financial system. Each company is an assessee, each entity is an assessee, but the consolidated financial system is the beginning point for the globe rules. So if India were to collect the top-up tax, how will it distribute within India? What is the mechanism for distribution? That also will be a subject matter. Again, which entity will bear more tax? On an administrative side, I find just I will leave it out as an imagination of problems, not necessarily they are all problems. I will say, number one, there should be a system of finding information about globe rules being complied across the globe. In the sense, there should be a common platform to understand globe rules have been adhered to. Number two, there should be a system of understanding that the top-up taxes have been paid in the country where it's supposed to be paid. Now, that means it should be visible to across the globe about this kind of top-up tax. Third one is about dispute resolution. You may say, where should be the dispute at all? After all, if consolidated financial statement is a starting point, the number of adjustments are very minimal, and therefore there's certainty in the income determination. But one requirement which the Globe rule says is that the income shall be determined based on transfer pricing rules. If TP were to survive, then automatically disputes would arise in determining the arm's length price. And if the disputes on TP were to be settled at a later point in time, so do you have a common assessment mechanism also across the globe that if there were to be a change in one jurisdiction, will you change the globe tax also across the jurisdictions? This is the third confusion which you'll have. Then there are appellate remedies which will happen from time to time. So every time you make a change in the globe tax, you may also make a change in across the globe. So what is the mechanism of tracking those taxes? I think it's a very complicated matrix. We don't have solutions. Nobody has a practical knowledge. We can put our imagination to find problems, if I say. Some of the problems may not arise if it is a very simple structure. I think that the intent is to make it simple, but in actual application, it could be quite a complex scenario. So I would think the question which you asked is, if a country does not implement globe rules, what will happen? It will be kept out of the globe rules mechanism. It will not be able to collect the top-up tax. The tax which is supposed to be collected from there will be collected somewhere else if the globe rules were applied to that country, and the difference tax will go to some other country, which will happen. In fact, one of the discussion we talked about is the UAE. Many of these countries are also getting prepared for globe rules so that they get a tax base which otherwise will be surrendered to some other country. No country would like to have taxes surrendered to some other country for whatever reason. So very complicated rules. I've read it many times. Possibly it will require many iterations before we get an understanding as to how it works really.
Thank you, sir, for giving us the overview of the infamous Pillar 2. And this is what I was expecting to raise more questions than answers, because this is the way that we'll go through. That once we identify the problems, that is the point that we start identifying the solutions to those problems. And as you rightly mentioned, that it might be a little easier to implement in certain simple structures, but I assume that it was brought in to capture those structures which are not so simple and are a little opaque, and at some point using reverse entities or something of that sort. And you have tried to summarize Pillar 2 for us to the best of the capabilities. You have read it multiple times. I'm still scared of finishing my first reading. So, most of the people who will be viewing, they must have got really valuable insights on this concept and actually wherein to look to identify the problems and what could be the potential issues. So, sir, with this, these were the only questions for the panel from my side. There have been a bunch of questions from the participants, and I have selected 3 questions which are trying to cover all the things that we have discussed. So that requesting permission for the next 10 minutes also, sir, if all the panelists, and we can go on for the next 10 minutes.
Yeah.
Okay. So the first question, which squarely covers all the discussion that we have done today, has been impact of BEPS 2.0 vis-a-vis the transfer pricing implications on the emerging and small companies, also startups, and with the recent change in the UAE tax law. So the person who has asked has tried to cover all the topics of the discussion. So, sir, please, this question is open for the panel.
Rishabh, can you repeat the question again? Because there are so many moving parts. I heard it and I still need to hear it again.
Okay, sir, I'll try to break it down. So for the first part, it says the impact of BEPS 2.0 and transfer pricing implications on emerging and small companies, including startups.
Okay.
And the second part is their interplay with the recent changes in the UAE tax law.
I will answer the BEPS plan, at least, to be very relatively easier. Being a startup, it may not have the size which is required for Action Plan 2. There are companies which are kept out of the Action Plan 2. is the turnover of, say, 750 euros for the previous 2 financial years out of 4, that itself, the threshold is possibly will keep it out of action plan 2. I mean, pillar 2 requirements. So that should be easier. Transfer pricing will apply is what Globe rules also say. So it's a common problem whether you're a startup or not. But barring the threshold exemption, other things, if you're there are claims, but we have multiple which are in business and doing more than 750 million euros, they will of course have to contend with them.
Mr. Srinivasan, I think the one aspect which we can remind is that it's possible because of the low turnover they may escape BEPS 2. But so far as transfer pricing is concerned, irrespective of that, those will be covered under the transfer pricing regulations of the countries concerned.
Padam sir, any comments on the question?
No, I thought that's fine. I thought it was a fair answer to the question that is posed.
Gaurav sir, over to you for the UAE aspect.
Not a lot to be added here from a UAE perspective, quite frankly. Because simply stated, UAE is right now not in the space where it is looking at the Pillar 2 implementation full-fledged, right? In the sense that it has introduced the GMT at an STTR level, subject to tax rate level. But beyond that, it's in a wait and watch mode. If a lot of companies start introducing these norms, and therefore it starts feeling that it's losing out because other countries have anyway started taxing the top up, started collecting the top up tax, which otherwise it could have collected. Then yes, it would, as per the at least as per what the FTA has shared in the what do they call it, the awareness sessions, right? So yes, then it might probably relook at adding the 15% rate for very, very large company, which is an option it has left open anyway in the FAQs, which are there on its FTA's website. But that's pretty much it for the time, yes.
Right, thank you. The next question is regarding the withholding tax and the DTAs. So company A is a resident company or company incorporated in India, pays salary to its managing director who is a resident of UK. Will the salary paid to him be taxed in India or UK, or in what proportion? So I think it's a personal query, but even I would like to know it. It's not my query, but whoever has asked, it's a personal query.
All of us can add some flavor to it. I presume the MD is rendering services in the UK, and he's not a resident of India. And therefore, that salary income should not be liable to tax at all as in India. He's a non-resident for services physically rendered in UK, and therefore should not be liable to tax. Should be the portion which the managing director can take in the facts given to me. Multiple changes can happen if he's a resident, whether the 192 will apply for the employer or not apply. Even if the employer does not do 192 for a resident, whether the resident should still include it in the global income or not. These are principles which require some amount of discussion. There are views that 192 will not still apply because salary is not dependent on resident or non-resident status. It is based on where these services are exercised. Even the dependent articles will say where the employment is exercised. And therefore, 192 is not an obligation which the employer will have to discharge for services rendered in UK by the MD. But certainly the employee himself, the MD himself will be required to file a return taking care of the global income, because under India, the global income will be taxable for him. Broad rules, certainly there can be more nuances to it, which we can add.
Let me add certain twist to this question. Because the very unusual feature of an Indian company, MD residing in England, it's a very unusual feature. That means that MD is absolutely controlling the entire affairs remotely. In my opinion, that may not be necessarily the fact of the reality. He may be there, but he could be coming to India for the purpose of discharging some portion of the duty. And therefore, the question arises, to the extent he is present in India for those number of days, will he be taxable in India? That's the twist you can add to Article 16, sub-Article 2 of the Indo-UK Treaty, or under 912 principle to say that salary to the extent they're performing work in India is going to be taxable in India. And if the MD is therefore required to come to India and the Indian company is claiming a deduction while it's computing its taxable income, therefore it's claiming a deduction, then there cannot be a situation that the Indian company gets a tax break and the MD does not pay tax. We have a base erosion test and applied in Article 16.2. Therefore, to the extent of the presence in India in the course of discharging his services, to that extent, the MD could be liable to pay taxes in India.
Adding one more thing here, Rishabh. The MD, right? He's a director. It's not necessary that he's the employee. And in case, therefore, he's not the employee, would Article 16 even apply? In that case, Article 17, next one, gets triggered, which interestingly says that the director's fees or similar remuneration, that can be taxed by the jurisdiction where the company of which he is a director, that is resident, right? So at least the treaty gives that right to India to tax it. Now we'll circle back to the question that how would the domestic tax law interpret it? Would we have a short stay exemption? Again, short stay exemption is there in the context of salaries, income, and again, if this is not a salary income, I don't think the short stay exemption is something. If it is not a salary income, if it doesn't have an employment agreement, then I don't know whether the short stay exemption will be applicable in the first place or not. I think section 10, subsection 6 is relevant. But there again, another question is he an Indian citizen, or the fact that he's in UK means probably he has given up citizenship too?
I think in the question, he's a British guy.
That means the short stay exemption is not... short stay exemption is available for foreign citizens, yes. So, but that again is only in the context of salary income, if I recall correctly.
A quick follow-up question. Whether rendering of services in UK will expose the Indian company to a permanent establishment?
Obviously, it is immediate exposure because key decisions will be taken by him. So it may constitute a PE. One will have to study the local laws of UK also. But first principle application, I think a PE could be attractive. What will be the attribution of income to that PE is a different matter. That could be, to start with, there will be a PE. Whether there will be full attribution or a mere cost plus 10% or something. These are issues which we get.
Sir, is it only PE or there's a poem risk also?
UK has a poem risk also. They also have a place of effective management rules. And except that he can at best say he is working under MD under law, works under the control and supervision of the board, and therefore escape for him.
Right, sir. And now everyone will know if this query comes up to you personally for a professional opinion, you know. And okay. So with this, I think we should conclude. We are already above time that was allocated and given by our speakers to us. Just a quick statistic. There were more than 2,500 viewers today, and we've touched about 2,502 viewers by the end of the webinar. And from this, I conclude as the moderator for the panel and hand over to Piyush sir for the concluding remarks and the vote of thanks.
Thank you very much, Rishabh. Thank you very much. The panelists, the area of the knowledge, the way the members have joined, 2,500, and the number of questions speaks about the volume. It is a well-known, the panelists have covered all the three areas, that is history of international tax, current controversy, and even the future. Starting from the latest important judgments, from where the controversy arises, what would be the future of it? What is the future of international taxation when the global minimum tax comes into play, pillar 2, VDA taxation? I think so. International tax per se is a complex, and to cover it, all these topics in 2 hours is really remarkable, I believe. And it's time to end the sessions. We are already running 15 months late, and I am sure that the participants have benefited immensely. So my special thanks to the SP Singh sir for his opening remarks and all the panelists, Sri Padamchand Khincha sir, Gauravji Singhal, Srinivasan sir. And also thank to Rishabh Agarwal for covering all the questions, which covers, as I said, history, present controversy, and the future about international tax. Sir, at the Direct Tax Committee, we are trying to minimize this number of sessions, but make it very, very, very interesting. It's not that you do a weekly sessions, you do 2 weekly. We do it once in 3 months. Last we did it for Finance Act 2023. And there was also a similar number of participants which were present over there and similar number of questions which arose. So you are the people, the panelists who actually always are available for the Direct Tax Committee programs. That makes our programs very special. The topics are also very special. So my special thanks to all of you. My thanks to the participants also and the teams. Of course, my thanks to Chairman for giving me this opportunity to present this concluding remarks and vote for thanks. Thank you very much. Good evening. Good night. Thank you.
Thank you very
We'll
much.
end this session.
Thanks a lot.
Thank you, sir.
Thanks a lot to everyone. Good night. Be safe. Control room, please conclude the proceedings.